In breaking news, we've got a 6-3 decision coming out of the United States Supreme Court that rewards Donald Trump once again for bad behavior. That's a third win for Trump at the Supreme Court in about a week and a half, and the second in the last 24 hours. This one blocks an order by a San Francisco federal judge, Judge Alsop, to force the Trump administration to rehire 16,000 probationary employees. They're back on the unemployment line because of this ruling by the United States Supreme Court. 6-3. This is now the third one, 6-3, and 2-5-4 is all in favor of Donald Trump. I'll break it down for you. I'll compare and contrast. I'll tell you what it means for another case that's pending in Maryland, in which a Maryland judge had a preliminary injunction to rehire virtually the same people. I'm Michael Popok, speaking truth to you on Legal AF. We got the order list from today, Tuesday, on the heels of the Supreme Court supporting Donald Trump's unconstitutional removal of people without due process to El Salvador, putting them to rot in El Salvador in jail, supported now by the United States Supreme Court. We now have this ruling at about 12 o'clock on Tuesday. This one is called the application for stay presented to Justice Kagan and by her referred to the court is granted. That means they're granting the Trump administration stay. The district court's injunction was based solely on the allegations of the 9 not-for-profit organization plaintiffs in this case. But under established law, those allegations are presently insufficient to support the organization's standing. This order does not address the claims of the other plaintiffs, which were the labor unions, which did not form the basis of the district court's preliminary injunction. Justice Sotomayor would have denied the application for stay by Trump. Justice Jackson would have declined to reach the standing question based on her prior rulings about there's no emergency relief required here. What does it mean? It means that 16,000 people ordered to be reinstated by the Donald Trump administration are now back on the unemployment line, because the Supreme Court has found that they don't like this group of 9 not-for-profits. They don't think they have unique injury. And for some reason, they have ruled that the judge didn't base his injunction on the labor union. The largest labor union representing federal employees was also a plaintiff, but they somehow argue, well, that's the injunction isn't tied to them. How can it not be tied to them? It's their people who got fired. So we have this in the order list. Now, let me explain what it means. In the context of all the cases that are out there, there's a second case that is very, very similar to Judge Alsop's case from San Francisco. It's Judge Bredar's case out of Maryland. And just a day or so ago, he expanded his preliminary injunction to cover 19 states and almost all the same overlapping federal agencies, including the Office of Personnel Management and the Department of Defense. So his order is still in place, but the judges have an application before them to stay that as well. Now, this one may go differently. Not to get too inside baseball, but I don't think they have a quote unquote standing problem for the plaintiffs in that case. But if this court determines that they do, they're going to toss that injunction as well. They're going to grant the Trump administration block, and these 16 or 20,000 probationary employees are going to be refired. Not rehired, refired. Now, they did it. The two judges came at it a different way. Alsop said it was a violation for the Trump administration under the Administrative Procedures Act, which says you can't be arbitrary and capricious in the way that you execute your policy. You have to give notice. You have to have a hearing, all sorts of things. Judge Bredar said it was a violation of federal law about how you reduce forces. A reduction in force, a RIF, has to be done with notice so you can prepare the states for the swelling unemployment lines created by the Trump economy and his policies. And they didn't do that either. So they both got to their places, their decisions in a different way, but ended up in the same place. Now, the question is going to come down to this archaic concept of standing. Standing is a concept that in order to bring a case in federal court, a little bit of a TED Talk law school breakout here. Standing means that you have a unique cognizable injury, distinct from other people, that creates a live controversy or case before any court. And if you don't have that, then it's like you're asking. Courts hate that because it looks like you're asking for an advisory opinion, and courts aren't in the advisory opinion business. They're in the live case or controversy business. And for that, they got to have real parties with real injuries in front of them. So standing is the number one way for the Supreme Court to kill a case. They'll look at their jurisdiction through standing more than any other. Oh, no standing? Sorry. Very interesting matter you have. Very interesting dispute about what they did and what you say he did to you, but you don't have standing, so get out of my courthouse. To have a ticket to the courtroom, you got to have standing. You got to be in the right court, right? We call that venue. The court's got to have personal jurisdiction over the people or companies. That's a personal jurisdiction analysis. I'll do a whole hot take on that another time. And then the court has to have subject matter jurisdiction over the dispute. And somewhere in that land of jurisdiction lies a standing. Because fundamentally, courts are courts, especially appellate courts, of limited jurisdiction. And they don't exert their power unless they have that live case or controversy in front of them. That's the whole standing argument. So when a Supreme Court wants to benefit Donald Trump, they'll look for any excuse, including standing, I assure you, or procedural niceties or something like that. Oh, you didn't dot the I across the T. Oh, you were so close to having standing, but you don't have standing. Very, very interesting. Come back to us another time. In the meantime, suffering, chaos, people on unemployment lines, impact on the economy. And what Donald Trump is doing by firing all these people, of course, is disconnecting the American people, right, from the U.S. government. So there's no responsiveness, there's no responsibility, there's no accountability, there's no services being provided, and people suffer. That's what he's trying to do. He's trying to shrink the federal government down to the size small enough to be drowned in a bathtub. And only then, and the wrecked economy and the carcass of a wrecked economy around it, will Donald Trump, his minions, the Federalist Society, the Heritage Foundation, and others be satisfied. So we're going to continue to follow what I said earlier at the top of the hot take. This is the third win for Donald Trump. A week and a half ago, reported in a 5-4 decision with Amy Coney Barrett. Actually, let me get it right. Amy Coney Barrett siding with the majority and John Roberts siding with the minority, and ruling that Donald Trump could just cut school funding, grants for teachers for inner city schools because he doesn't like the color of their party, doesn't like the color of their students, doesn't like the color of their teachers, something like that. So the Supreme Court said, no, he's allowed to cut that. 5-4, Amy Coney Barrett joining the majority. Then we had this decision from yesterday, which I did a report on, which is Donald Trump being rewarded for secretly deporting people without due process to El Salvador to get them out of federal jurisdiction. And now the Supreme Court, looking at the aftermath and the majority in a cowardly, unsigned 5-4 decision the other way, declaring that, well, for the people left in America, you can have due process, some limited due process, under a writ of habeas corpus petition. Look at my hot take for an analysis of that. But for those that are out here already, we're not even going to mention them in the order at all. It's as if it didn't happen. So that's a high five pop, champagne cork popping in the Trump administration for that one. And then we had the education one, this one, and now the new one blocking Judge Alsop. The question is Judge Bredar in Maryland and his overlapping order about rehiring these same probationary workers going to survive, or are they going to be cowards and say there's no standing? I'll follow it right here on Legal AF. You're here already. Keep a receipt. Hit the subscribe button. Help us continue to grow this pro-democracy channel. Until my next report, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.